Thank you, Kendra, for joining us tonight. And welcome to this month's Family Protection Planning webinar series. Tonight, we are featuring Kendra Strong, who is the founder and lead attorney at Strong Law. Kendra is a wife, a busy parent, a mom. Professionally and personally, she knows the challenges families face when planning is not complete or done improperly. And she knows what it's like to lose a family member. That is why she established Strong Law, specifically to focus on the needs of young families and professionals. Tonight, Kendra will share the process of what it looks like to work with her firm, the difference between the common estate planning documents. She will focus on probate and why you may want to avoid it. She'll talk about guardianship plans for minor children, the difference between wills and trusts, and incapacity planning. Welcome, Kendra. We're so excited to have you tonight.
Thank you so much, Nicole. I am so excited. I know the Broncos are playing, so I will be respectful of everybody's time and really just dive into it. I am so excited to share this information. It truly is just my greatest honor and pleasure to be in the position that I'm in with being able to educate my community and people who want to learn and have questions about estate planning because it's not always a topic that we are sitting around the dinner table talking about with our loved ones, our parents, our siblings. So, anytime I get the chance to speak about it, I just geek out. So, and I also have an excuse to share pictures of my beautiful family, which we just got our holiday photos back. So I snuck a few of those into this presentation since it is December. So we are going to talk about protecting your legacy with estate planning. First, I am an attorney, so we have to go through just a little bit of lawyer lingo and share that this really just is for educational purposes only. It does not constitute an attorney-client relationship, but I am sharing information that is deeply personal and I'm sorry, it's based on my personal and professional experience. So I'll weave in some personal stories here about some of my clients, our own family experience. And if anybody has additional questions, that's where I really encourage you to reach out because nobody's family fits in a box. Nobody's situation does. So it's always really, really important to ask those questions to the professionals. And then the agenda for the webinar, I have some questions for you that are attending or watching this later on. Then we're going to talk about legal guardians and then protecting your assets and some of the options that you have when it comes to estate planning. So I always like to kick it off with just a little bit about who I am. Nicole gave a fantastic, thank you so much for that introduction. But I do think that sharing my journey helps people to relate a little bit more. So my experience, I've been an attorney since 2017. I actually started out in the criminal law world and then ultimately settled in with personal injury for several years. So I was a litigator, I was in the courtroom. I essentially represented plaintiffs that were injured, whether it be a car accident or medical malpractice. And what I learned about myself during that time frame is I am a lover. I am not a fighter. And I just really loved meeting with the clients and being there for them and really being their advocate. But I hated the litigation side of it and just people fighting and having to deal with insurance adjusters. So, very shortly after I had my son, he was about 4 months old, and I had this wild idea that I completely wanted to change my career, change the area of law that I was in, and start my own law firm. So, in addition to raising my baby, I have been raising my law firm, Strong Law, and I am so excited about what I am doing and the clients that I'm serving. And a lot of it comes from the personal experience of being new parents and not really having anybody share with us the importance of estate planning and what would happen if something had happened to my husband, myself, or both of us. Um, so we'll kind of touch on that here in just a little bit. But first, I love to start out by asking you, who do you want to protect from court and conflict. Because the reality is, estate planning is not about you. It really is about the people that you love the most. This is where I usually tell people, right? Generally, when people come and have their estate plans done, you're not necessarily the one that's gonna see how it all pans out. It comes into play because your family, your kids, your siblings, somebody is having to kind of pick that up and manage what you've left behind. So if you want to leave it in a way that is the most respectful, and makes it as easy as possible for your loved ones, this is where I always encourage you need to get your estate plan done. So, a little bit more about who I am. This is my sweet family. So, we've got my husband, Petty, my son, Arion, in the middle. And then I'm a stepmom. So, I've got two bonus kids. That's Amory and Jahan. Amory just recently turned 18 and Jahan is 12. So, we've got a little bit of a crazy household with a huge age gap. And I share all of this because when it comes to blended families, it gets complicated, and I can share from firsthand experience, it's not always easy, and navigating those relationships while you're alive can be very difficult, but losing a family member and then having to navigate and deal with emotions and tensions and, um, all the things that come along when somebody passes away can be really difficult. So for me, I like to share my own personal stories of why. If something had happened to my husband and everything was left to me, it would not be his ideal plan that I would cut out his children. So again, it's really important to just take into consideration your family dynamics and what that might look like for you. Whether you're in a blended family situation or not, I can guarantee you might have some family relationships that you need to be careful with. So, some common myths. These are kind of the top four that I hear often when I start to talk about estate planning or when people call the office. So I'll start with the first one is you only need to plan if you have money. And that's just not accurate. Actually, it all comes down to how much input you want as it relates to the decisions about your life, your family, your body, like your medical decisions, and then, of course, your assets. And a little spoiler alert, if you think that you don't have a plan, you actually do, and it's the state's plan for you. So we'll move into that here in a bit. Number two would be my spouse gets everything anyways. Well, possibly, but you still need a plan. So in that situation, your spouse may not get everything that you think that they will. So it depends on how assets are titled, how beneficiary designations are. And then oftentimes, your spouse getting everything may actually not be what you want to happen in the end. So we really talk through those dynamics. And then I always like to also touch on this part of sometimes the dynamics in relationships. Oftentimes, what I find with the couples that I work with is generally one of them is the financial guru, right? They're the ones that are paying all the bills, has everything on auto pay. Like my own family, I will raise my hand. Um, I don't think my husband has any clue like who our mortgage company is because I have it all set up. It's on auto pay. It comes out of the bank. But right, so it kind of begs my question of, well, will your spouse be able to find everything? And will they know what to do with it once they do find it? Can they access it? Um, and then the worst question is what happens if you guys die together? Right? We do not like to think about this scenario, but it is a reality that sometimes we have to face. There's a reason why the president and vice president don't fly together, they don't drive in the car together. And there were so many stories of couples that have passed away in car accidents. I saw it often in my work as a personal injury attorney. And then, a very personal story to us is our neighbors unfortunately were the victims of a tragic murder. So they died together and left behind five minor children. So The default of my spouse gets everything is not always one that you want to rely on. Number 3, I don't have the money to pay an attorney for this. So my pushback to that is give me a moment. Like let me sit down with you and show you how much probate might cost your family. Not only in terms of money, but also time, the anxiety, the emotional toll that it can take on your family when you don't have the proper documents in place. And then number 4, I already have a will and my kids will get my life insurance. Well, with that one, again, I would kind of bust that by saying not all of your assets pass through a will. A will does not avoid probate. And if you do have minor children listed on your life insurance policies, hopefully you don't, they cannot inherit money outright. So that money would be locked up, through a conservatorship until they do turn 18. So again, any questions that somebody has, I am so happy to talk through it. And that's really what it means to work with an attorney is you get the opportunity to ask us all the nitty-gritty what if questions. So I want to start out by talking about guardianship. If you have minor children, or if you know somebody with minor children, ask them who would care for your children in the event of your death or incapacity. Right? Again, I don't like to use scare tactics, but coming from the personal injury world, parents were on date nights. They would get into a car accident and have to go to the hospital. What happens in that situation, right? So, who do you want to take care of your children? And I'll tell you that what happens in an emergency is so important to think about, right? So, the situation with the car accident, let's say me and my husband we're going on a date night on Sunday night. We leave our son Ariane with Alice, who is our babysitter. I actually asked Alice this question last week. I said, "What would you do if we did not make it home?" And her response was, "I'm going to call the police." Right? That's not exactly what I want to happen. And so that was an opportunity to educate her and reinforce, hey, this is what I do for a living. I need you to know my plan. So having a conversation with Alice about what she should do and what we prefer, because here's what's going to happen. If Alice were to call the police are going to respond and they're going to do what they can to try to get a hold of our family members. Well, what if I have family that doesn't live in Colorado? What do? They can't leave my son with Alice, the babysitter. That's a liability. So they may have to take your child into protective services until a blood relative or somebody else that you've nominated can get here to be with them, right? And the scary thing for me is that Ariane could potentially be taken into the care of strangers that he doesn't know or somebody that I wouldn't necessarily choose. So when we're talking about guardianship nominations, I kind of put together this quote that it's equally about what happens in an emergency as it is about who will raise your children in the long term if you could not. So, in the event that something did happen and a guardian needed to be selected, we can kind of play this like Russian roulette of who would you choose? Who would the judge choose? Okay, so generally, if you have not nominated somebody, there's going to be a procedure in which the court will designate a guardian. Multiple people or one person from your family or friend group could come and step forward to say, I want to be the guardian. Right? And that can present a problem, especially in a family like mine. I've got 4 wonderful sisters. My husband has 2 amazing sisters. I don't want them duking it out in court about who's the best, right? You've got to submit all this documentation, financial, criminal reports, background checks, credit reports. I don't want them to have to go through that battle and then ultimately leave it up to the judge to decide who looks the best on paper. So we come up with a solution in my office, and we call it the Kids Protection Plan. That we're going to help you to name legal guardians. And a lot of the times, parents can have a really tough time deciding who to name. So we help walk our clients through how do you decide? Who do you decide, right? Starting with your list of ideal people. So we'll go through that with you. Oftentimes, clients will say there are specific people in their lives that they absolutely do not ever want their children to be raised by. And so we take that into consideration and we can create documentation to protect their kids from that situation. I also tell clients that a decision is better than no decision. So, again, leaving the power to you, making sure your wishes are heard. Number two, it's not always about money. So, don't just pick your parents because they have a lot of money, right? You might want to pick guardians who have a really good relationship with your kids, who have a same or similar parenting style to you. What are their values like? What kind of activities or religion, integrity, ethics are they going to instill in your children? So, like I said, we have something in my office called the Kids Protection Plan. This is kind of a standalone document or set of documents, really, that will help you to provide instructions to your guardians. Medical information. We provide an ID card for you to carry in your wallet. Again, kind of thinking back to my personal injury days, something happens and you can't communicate. My hope is that the police or first responders can find this ID card and have the list of people who they need to call. And again, the long-term and short-term guardianship nominations. So moving on from kids, obviously I'm a mother, so very passionate about that, but also show me the money, right? Let's talk about the assets. We are all working so hard to build up um, our assets, whether it's home ownership. Maybe you want to have multiple real estate properties, certain dollar amount in your retirement account, right? Or if you're a business owner. So let's talk about what happens to those assets in the event of your incapacity or death. What happens? If you don't have a plan, Colorado does have a plan for you, and that plan is called probate. So that is the default plan. There are statutes that the judges, the attorneys, the courts, we have to follow those to a T. There are required forms that must be filled out with the court, deadlines in which to do this. And a lot of it, I know Nicole has experience with helping clients through the probate process on the real estate side. I tell people that probate is a lawsuit that your loved ones file against you, right? Your assets with your own money for the benefit of your creditors, because by statute, your creditors have a set period of time in which to make a claim. And that can delay a lot of things. It can delay when your family gets their inheritance. It can delay this the real estate sale. So, just kind of being aware that the default plan may not be what you want to happen. It dictates who is going to be your rightful heir. So, whether or not you have a spouse, children, a blended family situation, are your parents still alive? So, there's this whole little family tree that the state of Colorado gives us if you die intestate. Um, and so, my hope is that if you or your family members don't have to go through probate, if you can avoid it through advanced planning. So just a little bit more about what probate is. So we kind of just put together this very rough timeline. This is not exactly what it is, but you have somebody pass away, you get a death certificate, which is generally going to be public record when you file the probate action with the court. You have to wait for the court to appoint somebody as personal representative before that person can start acting on your behalf. And the really difficult thing is that generally your assets are going to be frozen during that time frame, right? When we pass away, by very nature of that, we cannot sign the sale documents to sell that property. So the court has to appoint somebody who essentially has the authority to then sell your property, walk into the bank and gather those bank accounts. Um, and so the probate process, what I generally share with people is you can expect to spend an average of 12 to 18 months in Colorado. Sometimes it can be quicker, 6 months, 9 months, but along the way, you're going to be incurring fees. So, um, another kind of silly thing about Colorado, we don't have a statutorily set dollar amount or percentage that people can charge, that attorneys can charge. So some of the fees that go into that are going to be court filing fees, appraisal fees for real estate, if you have to hire an attorney. A lot of people don't have the time or the knowledge or even want to deal with probate when they're already dealing with the death of a loved one. And so they will seek out probate attorneys who charge thousands of dollars to help them through that process. It's a very administrative process. Um, on a personal note, we lost my mother-in-law 2 years ago, um, a little over 2 years ago. And while we thought that she had a good estate plan in place, it did fail us. And we ended up having to go through probate. Nobody in my husband's family is fighting. They were all in agreement on everything. My sister-in-law was appointed as the personal representative, but unfortunately, due to the complication of some of the assets that she owned and how she had those titled, we are still in the probate court today with little to no information as to when we can close this out. We are just waiting and we are kind of at the court's mercy at that point in time. So, and I can guarantee she has spent way too much money on having to go through probate, which is just a shame that we didn't have the opportunity to look at this before she passed away. So, what is estate planning? In my office, my definition of that is it is documents for incapacity and death. Oftentimes, people have heard of wills or sometimes trusts. Those are kind of the two big ones that you're going to hear. Oftentimes, people will say, "Oh yeah, I just need a simple will," and I love to kind of push back on that and understand what they mean by that. What does a simple mean? What does a simple will mean to you? And then we have incapacity documents. So your healthcare directives, powers of attorney. So those come into play if you're incapacitated. And then business succession plan. So very, very important. If you are a business owner, what happens to your business? Who's going to keep running it? Who's going to shut it down? Who has the authority to access those bank accounts? So we look at all angles as it relates to estate planning, which is just the overarching term. To touch on the first one that most people are aware of, a last will and testament. By definition, it's really just a legal document that lists out your assets, who your beneficiaries are, your family dynamics, and that directs the judge on how to distribute your assets after death. Again, a will is actually not written for your loved ones. It's written for the judge to read and to ensure that that's going to be carried out. They basically are going to look at that. If anybody were to be contesting it, that would be handled through the probate process. Each side can get attorneys. So again, it just opens the door for conflict and litigation. So the other thing to be aware of is that your will does not control all of your assets. And again, I want to highlight that it doesn't protect your family from having to go through probate. So I want to share a little story here. My husband had a business partner and they invested in real estate property together. When they invested in this property, they had contracts written up and they took the property as joint tenants. So when the business partner passed away, those properties did not go through probate. They were not controlled by her will, despite the fact that she had written in those documents in her will. Instead, those properties came to my husband because he was joint owner on that title. And so again, this is just where I like to share with people is oftentimes we think that a will is going to take care of all of our assets, but that's not always true. So that's where it's really important to understand how you own assets, the implications of how you're taking title. Do you have beneficiary designations? All of that is so important to be aware. Get your financial house in order and really have an understanding of that. The other risk of having a will, if you have minor children, those beneficiaries are going to receive assets outright and unprotected. That can be a problem for some people's families. Oftentimes, I work with clients who share with me that they've got, adult children that are suffering from drug and alcohol addiction. That would be terrible, right? If they were to get a windfall of 10, 20, $50,000, oh my goodness, that could destroy their lives. How do we handle that? How do we protect that money from themselves and from maybe potential creditors? So having that conversation. The other thing as a mom of minor children, I don't think I want my 18-year-old getting a lump sum of money um, outright. In fact, my 12-year-old shared with us that if he got, 10, $20,000, he would go buy candy. So that's where his mindset is at. And he's not that far from 18. So just think about your own kids getting money outright. All that to say, for some families, for some people, wills are not enough. So I would just love the opportunity for you to sit down with an estate planning attorney and go through your assets. Find out what is the best tool for you rather than just kind of taking it into your own hands, downloading a form online or trying to DIY it like my husband's business partner did. So, moving on to revocable living trusts. These are the most common types of trust that you're going to hear estate planning attorneys talk about. It's a revocable trust, so that means you have the power during your lifetime to change it, to amend it, to revoke it. Um, you really have a lot of freedom and flexibility with the trust. So, who needs it? Right? There's not, again, a one size fits all, but generally with my clients, the ones that I see benefit the most from living trust are going to be property owners. So, homeowners, I work with a lot of real estate investors that want to protect those assets the right way. They want to ensure that they're passing those properties on to their loved ones in a way that maximizes taxes um, or tax benefits. They want to pass it in a way that doesn't result in them potentially losing the property or again going through fights. Again, a little pro tip, if you're a real estate investor and you have property outside of the state of Colorado, like without a doubt, I'm going to recommend a trust. This is where, with my mother in law, she owned real estate in Georgia, in Texas, and in Colorado. What happens when you have that situation? That's three probate cases. That is three probate attorneys that we had to hire to help us go through probate. And remember, I shared that we're still going through the probate process. We're being held up because Texas has some pretty interesting laws, and they are just like sitting on our case. They haven't moved it. Again, nobody's fighting. So, just having to navigate that as a property owner, it has been incredibly stressful. Parents with minor children, again, can benefit from having a trust because you have the flexibility to control when your kids would get their inheritance. So if you feel more comfortable with them inheriting from you at 25, 35, you can break it up into percentages. You can, dictate or have clauses in there that say, if, like in mine, if my children wanted to purchase a home, they can ask the trustee to make a distribution for a down payment, help pay for college. Um, so again, there's a lot of flexibility there, and I love it for minor children. Business owners, again, if I'm a business owner, if you're a business owner, you want to make sure that you have a plan in place that addresses your business interest and to make sure that you're not leaving a chaotic mess that's really complicated to deal with or unlock. Special needs beneficiaries, this goes without saying, you absolutely want to make sure that you protect any government benefits that they would be receiving. You do not want them receiving money outright. A couple weeks ago, I got a call from a woman who was just frantic because she was inheriting a large lump sum from her dad. And that unfortunately is resulting in her being kicked off of government benefits. So had he set up like a special needs trust, that could have protected her from losing those benefits. And then blended families. A trust, again, with the flexibility process, we can build in clauses that protect and honor those relationships. So I don't want to be the evil stepmother when I pass away. I certainly don't want my children, feeling any ill feelings towards me. And so we have protections in place that should my husband be the first spouse to pass away, we have assets going to the kids in a certain manner so that they don't feel slighted and they're not waiting for me to die. They can have a little bit of their inheritance at this point. The other side of it is we're protecting it. So I can't give it away. I can't write them out of the will or the trust. Their inheritance is protected the moment my husband passes away. And then, of course, anybody that just wants to avoid the probate process, it's worth considering a living trust and talking about the pros and cons of that. So, a little bit more, just as a recap of some of the advantages of having a trust, having your assets in a trust. It can avoid probate when properly funded. It is a private process. You have that protection, like I talked about, for minors and blended families. A really cool thing about the trust is the incapacity management. So, a difference between a will versus a trust, the will only comes into play when you die, whereas the trust can actually serve to benefit you if you're incapacitated because you are a beneficiary of your trust as well. My favorite is that it saves time with a shorter administrative process. Um, you have immediate access to funds and assets versus the probate process. Remember, you have to have a personal representative appointed, and then you have to take that piece of paper and you have to go down to the court, that you have to go down to the bank. Whereas, as the trustee, your successor trustee would be able to access those funds immediately with the documentation that they already have and then provides guidance and instructions. And in my office, it's more cost effective to set up a trust than it is to go through probate. Um, and then you can, if you have a taxable estate, we'll talk about tax planning and that as well, and how to ensure that you are putting provisions in there that help to minimize and defer some of the taxes that you or your loved ones may have to pay. The other really cool thing about a trust is you can build in subtrust. And so I always give my clients this option that they can provide protection for surviving spouses or for their beneficiaries to protect that inheritance that they would get from future creditors, lawsuits, divorces, bankruptcy. So a lot of really, really cool advantages to utilizing a trust versus a will. My analogy with a trust, I like to tell people that I'm a Target girl. So think about if you are walking down the aisle of Target and you didn't grab a cart, so you're walking through. It's Christmas time. So you're grabbing this and you're grabbing that, and you go by the dollar, the $3 section, and you start like your hands are full. Okay. And then let's say you slip and fall. Everything that you're carrying is going to fly out of your hands. It's going to go underneath this aisle. It's going to roll over here. Some things might crash and break. Um, that's what it's like when you have a will, because your family is having to search and figure out, where are your assets? Where does my mom bank? Like, ask yourself these questions. If something happened to you, who's gonna, like, do they know where you have your checking account? I have an online savings account. Is somebody gonna know to call Ally Bank and let them know that I've passed away and you need to get the money that's in there? So that's all part of when we think about a trust, we put all of your assets inside a grocery cart. And that way, if you slip and fall, the grocery cart, nothing happens to the things inside. The next person can just come and continue to push along that cart just as you were. So that's maybe, hopefully I explained that the right way. But that's my shopping cart analogy, because when you set up a trust, generally we're going to give you advice and direct guidance on how assets should be held, how your beneficiary designation should be listed on your accounts so that we make sure everything flows through the trust and carries out the wishes and the plans that you had. So, how can you do the right thing for your family? You have a couple of options to create your estate plan. Option one, of course, is to do it yourself. You can handwrite your own will, get it notarized, have witnesses. You can download an online form. There are several options, several platforms out there. I have seen them all. And then you can work with an attorney. And I know that there's a plethora of options, some great attorneys that Nicole has already had on here. But always just kind of knowing that not all lawyers are the same, right? You always want to find somebody who's going to match your personality, who is, you know, eh, ask them what services they're providing for you rather than just the documents themselves. So this is kind of my soapbox on the one size fits all, leaving your family at risk, and the DIY, right? Again, there's all these options out here, and from my experience, those are the ones that fail. They leave holes in your planning, and it's going to leave your family with a big mess. Oftentimes they're fill in the blank, and people don't fill in those blanks the right way. Um, I had a client come to me. She had printed off this form online. She filled it all out, never signed it. So, an unsigned will is not going to do anything for your family. But when I reviewed it, she had just had 1-year-old twins. And in the where it said, like, name a guardian for your children, she put her cat's name. Like, had she signed that, what would they have done? That would have been, like, a huge argument. The court would obviously never do that, and then they've gotta figure out, well, who did she mean to leave her children with, right? So, that's just where my little caution is of the DIY planning is there's always going to be questions, and a lot of my clients will tell me, "Oh my gosh, thank you so much. I feel so much better because at least I had a real person to ask these questions to, right? Sometimes it's just getting that advice of that help and understanding really can help put you at ease and at mind. The other issue again is oftentimes you're just getting one form document, right? If you download a will online, that is not enough to protect you for incapacity. Again, it may not avoid estate taxes. You could lose your assets to the Department of Unclaimed Property. If your loved ones don't have an asset inventory and they don't know where your accounts are, you can end up with donating your money to the Department of Unclaimed Property and they've already got billions. So my hope is to help clients choose better. And in my biased opinion, working with an attorney is better, especially if you want to ensure that the people that you love are going to stay out of court, stay out of conflict, have the ability to ask questions and talk you through different scenarios. If you want a minor, like a kids protection plan that is solid, you're going to want to work with an attorney. Avoiding probate, how do you do that? And then again, if you have a blended family, like in my opinion, it's a must. Like you must work with an attorney to ensure that you're not going to have hard feelings at the end of the day. And then making sure that your plan will work for your family. Again, I shared my mother-in-law, she did work with an attorney. She worked with an attorney, she had a trust set up, and unfortunately, that attorney was just doing a document-based service, right? Turning and burning. Let's see how many clients I can get in here. And he wasn't providing value. He wasn't developing a relationship with his clients. And so ultimately, the plan that he created for her, it wasn't even signed properly, right? The bare minimum that an attorney should be doing is making sure that their clients are signing and notarizing these documents the right way. So making sure that you're choosing an attorney that's going to provide you more value than just documents. And that's really what my firm is based on is almost a client services or a client service or customer service base. You're going to get so much more than documents. You really get a relationship and a bunch of other stuff. So My pro tip is that most DIY estate plans fail and they end up in court. You know, 2 people around me personally, that is exactly what happened. So, what have I done differently? This is where I took those experiences, the learning lessons from my mother-in-law, my husband's business partner, probate cases, accidents when I was doing personal injury, and I said, there has got to be a better way to do estate planning. I don't want to just have my community have the traditional, I'm getting ready for retirement. Let's check this off the box. No, you need a plan for your entire life. You need a plan that is going to look the way that you want it to look when you've got minor children. And then you need a plan that's going to look different when you have adult children, right? The way that my plan looks right now with a 3-year-old boy is going to look vastly different when he's in his 30s and 40s, God willing. I live that long. So, at my firm, we call it life and legacy planning because truly you need to have these documents in place for all periods of life. Um, if we were to become incapacitated, right? There are studies out there that we are more likely to become incapacitated one or more times in our life. And so you want to make sure that even if it's for a short period of time that you're in the hospital, that you've got the right document in place so that somebody can make decisions for you if you cannot. Everything that I do is comprehensive. So again, we don't provide one-off documents. If you just have a will, if you just have a one power of attorney, that is not going to serve your family and it's going to leave those holes where they may have to end up in court. Everything that I do is flat fee. So you can kind of ask around, shop around, ask, how do you bill? Find an attorney, find a law firm that's going to match what you're looking for. Because at the end of the day, again, we are here to help transition so that your family is not having to deal with more stress or having to deal with the court process. So that's what I have for you guys tonight. I have my contact information listed if you have any questions or want to email me. If you are, hopefully a Colorado resident, you can also use the QR code to schedule a planning session, or again, just reach out and schedule an intake call with us, and we are happy to answer your questions, get you scheduled for a strategy session. Like I said, that one of the first things is, what do you own? Let's go through that. Let's talk through these really, really tough questions because you're not alone. And a lot of people might have the same question as you. And I know how easy it is to put off. So we are at the end of the year. If you want to put it on your goals to get this done finally in 2025, that is going to be the best time because there's no time like the present. So thank you for sharing your evening with me. I really appreciate it.
Thank you so much, Kendra. That was awesome. So many good takeaways for me. I just have tons of notes, and I just think, driving home that point that estate planning is not about you, it's about the people that you love the most is just it really hits home, and like your emphasis on your children, whether they're young, whether they're special needs, if they have other things that would prevent them from you wanting them to take on a big um inheritance. There's so many different factors, and I think it was really great that you talked about the DIY planning. I've heard this a little bit before, but I think people think, oh, I'll just hop online. We have so many online tools these days, but it's just not customized. It's unfortunate because the money that you do spend on that will oftentimes be wasted, the time, because it's just not going to hold up. um, it's not unlike, documents that I do for clients when people want to do their own, contracts and things like that. So, but thank you so much. I will put Kendra's contact information in the comments as well, so you can reach out to her. You'll have this. And I do hope that you'll reach out to her and kind of start that conversation and see how she can help you. It's really an important thing to do for your family. So thank you for being here, and thank you for sharing all of your knowledge with us.
Absolutely. You're so welcome.
All right, thanks everybody. Reach out if you have any questions, and I hope you have a great rest of your evening.